Good morning, everyone. We are the Group 2, and we were assigned to discuss and differentiate the case of Rene A. Sagisag versus Executive Secretary Paquito and Ochoa with the GR number of 212426 and the Suzette Nicolas Zombie. The case of Suzette Nicolas Sombilon versus Alberto Romulo pursuant to Visiting Forces Agreement between Republic of the Philippines and the United States entered into February 10, 1998. The United States, at its request, was granted custody of defendant Smith pending the proceedings. The Romulo-Kenney Agreement were arranged between and signed by Ambassador Christy Kenney and Chief State Prosecutor Jovencito Zuno and Secretary of Foreign Affairs Alberto G. Romulo. In accordance with the Visiting Forces Agreement, they provided for the transfer of Smith from Makati Jail to a detention facility operated by the U.S. government and dictated the condition of his detained there. Petitioner contend that this undertaking violate another provisions of the Constitution, namely, that providing for the exclusive power of the court to adopt rules and procedure for all courts in the Philippines. Petitioners argue that they violate the Visiting Forces Agreement under the Criminal Jurisdiction Article 5 established the sole jurisdiction of Filipino authorities over U.S. personnel who violates any Philippine laws. But United States military authorities have exclusive jurisdiction over crimes against American property, security, or personnel, and retain the rights to exercise the sole jurisdiction over any personnel accused for committing a crime during the performance of their official. Rene A. Sagisag versus Executive Secretary Paquito and Ochoa, GR number 212426, January 12, 2016. Petitioners question the constitutionality of Enhanced Defense Cooperation Agreement between the Republic of the Philippines and the United States of America. Claiming that EDCA is not a treaty, petitioners allege that respondent committed grave abuse of discretion amounting to lack or excess of jurisdiction when they entered into EDCA with the U.S., claiming that the instrument violated multiple constitutional provisions. Petitioners move that EDCA must be in the form of treaty in order to comply with the constitutional restriction under Section 25, Article 18 of the 1987 Constitution. It states that foreign military bases, troops, or facilities are not allowed in the country unless the following conditions are sufficiently met. First, it must be in a form of treaty, and second, the treaty must be duly concurred in by the Senate and ratified by a majority of votes cast by 2/3 of all the members of the Senate. The principal reason for motion for reconsideration is evidently petitioners' disagreement with the decision that EDCA implements the Visiting Forces Agreement and Mutual Defense Treaty. Petitioners argue that EDCA provisions fall outside the allegedly limited scope of the Visiting Forces Agreement and Military Defense Treaty because it provides a wider arrangement than Visiting Forces Agreement for military bases, troops, and facilities, and it allows the establishment of United States military bases. The main differences of the two cases. The first case is Suzette Nicolas Simbolon versus Alberto Romulo. Agreement generally lists the respective rights, duties, and obligations of a negotiated arrangement. That's why under the Visiting Forces Agreement, The request of United States of America of the custody of Daniel Smith was granted, but petitioners argued that the detention would be by the Philippine authorities. Under Article 5 of the Criminal Jurisdiction of Visiting Forces Agreement, who violates any Philippine law, the sole jurisdiction will be established by the Philippine authorities. The second case is the Rene Sagisag versus Executive Secretary Paquito and Ochoa. EDCA is a supplemental agreement to the previous Visiting Forces Agreement. Therefore, EDCA is not a treaty. It is executive agreement who violates the constitutional restriction under Section 25, Article 18. It states that foreign military bases, troops, or facilities in the country are not allowed in the Philippines. It must be under a treaty and must be duly concurred in by the Senate. The President has the power to terminate the Enhanced Defense Cooperation Agreement, but he needs this agreement to protect the Philippines as being the Commander-in-Chief. EDCA is considered an executive agreement, therefore, may be bound to the President without the need of senatorial votes for its execution.
The Military Bases Agreement of 1947, or the MBA, was signed on March 16, 1947 between the Philippines and the United States. This pact gave the United States the right to build, maintain, and operate air and naval bases in the country. For a period of 99 years, it granted for the use of around 23 named bases and services by Americans. The VFA is a bilateral agreement between the Philippines and the United States that lays forth the term and circumstances for U.S. armed forces to enter and visit the Philippines, paving the door for operations like balikatans or shoulder-to-shoulder or large-scale joint military training. The Enhanced Defense Cooperation Agreement, or EDCA, is a bilateral agreement between the United States and the Philippines that aims to strengthen the alliance between the two countries. The pact authorizes the U.S. to send soldiers to the Philippines for extended periods of time and to build and operate facilities for both American and Philippine forces on the Philippine bases. No longer has the right, power, and authority to construct, install, maintain, and employ any type of facility, weapon, substance, device, vessel, or vehicle or system unlike in the old treaty. The old Military Bases Agreement gave this right to the U.S. EDCA does not allow the U.S. EDCA strictly adheres to the limit under the VFA. EDCA does not allow the U.S. to operate military post-exchange facilities, which is free of customs, duties, and taxes, unlike what the expired MBA expressly allowed. Military presence in the country. In sum, EDCA is a far cry from a basing agreement as was understood by the people at the time that the 1897 Constitution was adopted. Nevertheless, a comprehensive review of what the Constitution means by foreign military bases and facilities is required before EDCA can be deemed to have passed judicial scrutiny. Military bases, including the limits of territorial waters and airspace adjacent or in the vicinity of those bases. The only standard used in determining the extent of its control was military necessity. Under the MBA, the U.S. was given the right, power, and authority to control the movement and the operation of all types of vehicles within the vicinity of the bases. Under EDCA, the U.S. is merely given temporary access to land and facilities. In the 1947 MBA, the U.S. was granted the automatic right to use any and all public utilities, services, and facilities, airfields, ports, harbors, roads, railroads, bridge, viaducts, canals, lakes, river, and stream in the Philippines in the same manner of the Philippine military forces enjoy that right. No such agreement appears in EDCA. No longer has the right, power, and authority to construct, install.
EDCA is not a treaty despite the, the presence of this provision. The very nature of EDCA is provision and subject matter. Categorized, it is an executive agreement that is not covered by the Article 18, Section 25. Restriction. Executive agreement may dispense with the requirements of Senate. Concurrence because of the legal mandate with which they are concluded as called from the deliberation of Constitutional Commission, past Supreme Court decision, and works of note. Scholars, executive agreement merely in lab arrangement on the implementation of existing policies, rules, laws, and agreements. Under international law, the distinction between a treaty and international agreement or even executive agreement is irrelevant for purposes of determining international rights and obligation. There remain two very important features that distinguish treaties from executive agreement. First, executive agreement must remain traceable to an express of implied authorization under the Constitution status of treaties. The absence of this precedent puts an validity and effectively of executive agreement under serious question, for the main function of the executive is to enforce the Constitution and the laws, inactive by legislature not to defeat or interfere in the performance of these rules. In turn, executive agreement cannot create new international obligations that are not expressly allowed or reasonable in the law. Their purport to treaties are by their very nature considered superior agreement, which are the Senate. A treaty is regarded as being on the same level as a statute. Executive agreement is treated differently. The decision goes to great length to illustrate the sources of EDCA's validity. In that, as an executive agreement, it fell within the parameter of the BFA and MDT, and seamlessly with the whole web of Philippine law. Supreme Court find no reason for Enhanced Defense Corporation Agreement to be declared unconstitutional. It fully conformed to the Philippine legal regime through the MDT and VFA. It also fully conformed to the agreement continued policy to enhance our military capability in the face of various military and humanitarian issues. Thank you.
On the brighter side, this agreement is good for our country. Opponents of the Enhanced Defense Cooperation Agreement, or EDCA, should bear in mind that on the whole, this new agreement with the United States has more advantages than drawbacks. Philippine Navy of their own would have a hard time securing our coastal waters, and as this would be so costly and demand more resources from our government and the Philippine military. With this agreement, our naval ships can more easily deter any incursions near our shores and shield Filipino fishermen from harm and harassment by hostile country. The Enhanced Defense Cooperation Agreement is legitimate and as in consonance with existing international laws and agreements on mutual defense. We should be thankful that the United States has come to our aid sincerely. Besides, although the agreement has been signed, it is still being reviewed to satisfy criticism and to see if it has violated any laws, which is most unlikely. EDCA is good for the Philippines, considering our ongoing dispute with China. Let's all look at the benefits of enhanced defense cooperation agreements brings us.
I am Ana Rose Bisaya from B.Ed 1 and this is the case of Sombilon versus Romulo. General Register number 175888, February 11, 2009. Respondents Lance Corporal Daniel Smith is a member of United States Armed Forces. He was charged at the crime of rape committed against a Filipina. Petitioner herein, sometime on November 1, 2005, as follows. The undersigned accused Lance Corporal Daniel Smith, Staff Sergeant Chad Brian Carpenter, Dominic Duplantes, Kate Silkwood, and Timoteo L. Soriano Jr. of the crime of rape under Article 266A of the Revised Penal Code as amended by Republic Act 8353 upon a compliant under oath filed by Suzette S. Nicolas, which is attached hereto and made an integral part hereof as Annex A, committed as follows. That on or about the first day of November 2005, inside the Subic Bay Freeport Zone, Olongapo City, and within the jurisdiction of His Honorable Court, the above-named accusers, being then members of the United States Marine Corps, except Timoteo L. Soriano Jr., conspiring, confederating together and mutually helping one another, with lewd design and by means of force, threat, and intimidation, with abuse of superior strength, and taking advantage of the intoxication of the victim, did then the end their willfully, unlawfully, and feloniously sexually abuse and have sexual intercourse with a carnal or knowledge of one Suzette S. Nicolas, a 22-year-old unmarried woman inside the Starex van with plate number WKF162 owned by Starways Travel and Tours, with office address at 8900 P. Victor Street, Guadalupe, Makati City, and driven by accused Timoteo L. Soriano Jr., against the will and consent of the said Suzette S. Nicolas, to her damage and prejudice. Contrary to law. Pursuant to the Visiting Forces Agreement, or VFA, between the Republic of the Philippines and the United States, entered into on February 10, 1998, the United States, as its request, was granted custody of Defendant Smith pending the proceedings. During the trial, which was transferred from the Regional Trial Court, or RTC of Zambales, to the Regional Trial Court of Makati for security reasons, the United States government faithfully complied with its undertaking to bring Defendant Smith to the trial court every time his presence was required. On December 4, 2006, the Regional Trial Court of Makati, following the end of the trial, rendered its decision, finding defendant Smith guilty. Wherefore, premises considered, for failure of the prosecution to adduce Staff Sergeant Chad Brian Carpenter, Lance Corporal Dominic Duplantes, all of the U.S. Marines Corps assigned at the USS Essex are hereby acquitted to the crime charge. The prosecution having presented sufficient evidence against accused Lance Corporal Daniel J. Smith, also of the U.S. Marine Corps at the USS Essex, this court hereby finds him guilty beyond reasonable doubt of the crime of rape defined under Article 266A, Paragraph 1 of the Revised Penal Code, as amended by Republic Act 8353, and in accordance with Article 266B, first paragraph thereof, hereby sentence him to suffer the penalty of reclusion perpetua together the accessory penalties, provided for under Article 4 of the same code. Pursuant to Article 5, Paragraph number 10 of the Visiting Forces Agreement entered into by Philippines and the United States, accused Lance Corporal Daniel J. Smith shall serve his sentence in the facilities that shall thereafter be agreed upon by appropriate Philippine and United States authorities. Pending agreement on such facilities, accused Lance Corporal Daniel J. Smith is hereby temporarily committed to the Makati City Jail. Accused Lance Corporal Daniel J. Smith is a further sentenced to indemnify compliant Suzette S. Nicolas in the amount of 50,000 as compensatory damages, plus 50,000 as moral damages. So ordered. As a result, the Makati Court ordered Smith detained at the Makati Jail until further orders. General Register Number 175888, February 11, 2009.
Facts, issues, ruling, and preamble of the case. Clark and Subic and the other places in the Philippines covered by the RP-US Military Bases Agreement of 1947 were not Philippine territory, as they were excluded from the cession and retained by the U.S. Accordingly, the Philippines had no jurisdiction over these bases except to the extent allowed by the United States. RP-US Military Bases Agreement was never advised for ratification by the United States Senate, a disparity in treatment because the Philippines regarded it as a treaty and had it concurred in by our Senate. Subsequently, the United States agreed to turn over these bases to the Philippines. With an expiration of the RP-US Military Bases Agreement in 1991, the territory covered by these bases were finally ceded to the Philippines. Whether or not the presence of U.S. Armed Forces in the Philippines territory pursuant to the VFA is allowed under a treaty duly concurred by the Senate and recognized as a treaty by other contracting states. Issues: whether or not the presence of armed forces in the Philippines territory pursuant the VFA is allowed under the treaty duly concurred in by the Senate and recognized as a treaty by other contracting state. Petitioners contend that this undertaking violates another provision of the Constitution, namely that the providing of the exclusive power in this court to adopt rules and procedure for all courts. Article 8, Section 5, they argue that to allow the transfer of custody of the accused to foreign power is provide for a different rule of procedure for that accused. which also violates the Equal Protection Clause of the Constitution, Article 3, Section 1. Ruling. This court finds that it is for two reasons. First, as held in Bayan versus Zamora, the VFA was duly concurred by the Philippine Senate, has been recognized as treaty by United States as attested and certified by the duly authorized representative of United States government. The fact that the VFA was not submitted for the advice and consent of the United States Senate does not detract from its status as a binding international agreement or treaty recognized by the said state. For this is a matter of internal United States law. The second reason has to do with the relation between VFA and the RPUS Mutual Defense Treaty of August 30, 1951. This earlier agreement was signed and duly ratified with the concurrence of both the Philippines Senate and the United States Senate. Clearly, therefore, joint RP-US military exercises for the purpose of developing the capability to resist an armed attack falls squarely under the provision of the RP-US Military Defense Treaty. The VFA, which is instrument agreed upon to provide for the joint RP-US military exercises, is simply an implementing agreement to the main RP-US Military Defense Treaty. The preamble of the VFA states, reaffirming their obligation under the Mutual Treaty of August 30, 1951, accordingly, as an implementing agreement of the RP-US Mutual Defense Treaty, it was not necessary to submit the VFA to the U.S. Senate for advice and consent, but merely to the U.S. Congress under the case Zablocki Act with 60 days of its ratifications. It is for the reason that the U.S. had certified that it recognized the VFA as a binding international agreement, a treaty, and this substantially complies with the requirements of Article 18, Section 25 of our Constitution. The provision of Article 18, Section 25 of the Constitution is complied by the virtue of the fact that the presence of the U.S. Armed Forces through the VFA is presence allowed under the RP-US Mutual Defense Treaty. The VFA provides that in cases of offenses committed by a member of the armed forces in the Philippines, the following rules apply. The custody of any United States personnel over whom the Philippines is to exercise jurisdiction shall immediately reside with the United States military authorities, if they so request, from the commission of the offense until completion of all judicial proceedings. This court finds no violation of the Constitution. Nothing in the Constitution prohibits such agreement recognizing immunity from jurisdiction or some aspect of jurisdiction. In relation to long-recognized subjects of such immunity like heads of the Senate, head of states, diplomats, and member of the armed forces contingents. A foreign state allowed to enter another state's territory. On the contrary, the Constitution states that the Philippines adopt the generally accepted principle of international law as a part of the law of the land. Applying, however, the provision of VFA, the court finds that there is a different treatment when it comes to the detention against custody. The moment that accused has to be detained after conviction, the rule that governs in the following provision of the Visiting Forces Agreement.
VFA or Visiting Forces Agreement is the confinement or detention by Philippine authorities of United States personnel should be carried out in facilities agreed on by appropriate Philippines and United States authorities. United States personnel serving sentences in the Philippines should have the right to visit and material assistance. It is clear that the parties to the BFA recognize the difference between custody during the trial and detention after conviction because they provided for specific arrangement to cover detention. Not only that detention should be carried out in facilities agreed on by authorities of both parties, but also that detention should be by Philippine authorities. Therefore, the Romulo-Kenney Agreements of December 19 and 22, 2006 are agreement on the detention of the accused in the United States Embassy are not in accord with the BFA because such detention is not by Philippine authorities. Next, the court addresses the recent decision of the United States Supreme Court in Medellin v. Texas 552 U.S. number 06984, March 25, 2008, which held the treaties entered into by the United States are not automatically part of their domestic law unless these treaties are self-executing or there's an implementing legislation to make them enforceable. First, the BFA is a self-executing agreement as the term is defined in Medellin itself because the parties intend its provision to be enforceable precisely because the agreement is intended to carry out obligation and undertaking under the RP-US Mutual Defense or MDT. Secondly, the BFA is covered by implementing legislation, namely the Quezada-Bloque Act, inasmuch as it is the very purpose and intent of the U.S. Congress that executive agreement registered under this act within 16 days from their ratification be immediately implemented. BFA differs from the Vienna Convention on Consular Relations and the Avena decision of the International Court of Justice, ICJ. Subject matter of the Medellin decision, the Convention, and the ICJ decision are not self-executing and are not registrable under the Quezada-Bloque Act, and thus lack legislative implementing authority. Finally, the RP-US Mutual Defense Treaty or MDT was advised and consented to by the U.S. Senate. Here are some principles of BFA or Visiting Forces Agreement. The rule in international law is that a foreign armed force allowed to enter one's territory is immune from local jurisdiction except to the extent agreed upon. The status of forces agreement involving foreign military units around the world vary in terms and conditions, according to the situation of the parties involved, and reflect their bargaining power. But the principle remains: the receiving state can exercise jurisdiction over the forces of the sending state only to the extent agreed upon by the parties. As a result, the situation involved is not one in which the power of this court to adopt rules of procedure is curtailed or violated, but rather one in which, as is normally encountered around the world, the laws, including rules of procedure of one state, do not extend or apply, except to the extent agreed upon, to subject of another state due to the recognition of extraterritorial immunity given to some bodies as visiting foreign armed forces. It was not the detention of the framers of the 1987 Constitution in adopting Article No. 23, Sec. 25, to require the other contracting state to convert their system to achieve alignment and parity with ours. It was simply required that the treaty be recognized as a treaty by the other contracting state.